Hi guys, welcome to Satya Study Junction. In today's leading cases, we are going to discuss the case of Hindu law Rameshwari Devi appellant versus State of Bihar respondent, which has been referred from Year 2001 Supreme Court 735. The subject of the case is this case is based on the section 10 of the Hindu Succession Act. First, we'll discuss the facts of the case. Number 1. Narayan Lal was working as the managing director in the Rural Development Authority Bihar, who married for the second time with Yogmaya Devi on 10 April 1963, while his first wife Rameshwari Devi appellant was still alive. Second, Narayan Lal had a son for the first wife and 4 sons from the second wife. Narayan Lal died in 1987, and after his death, a dispute arose between the two wives over the pension and the gratuity amount. Now we'll see what the single bench of the High Court said. This court delivered a judgment that the children of Yogmaya Devi are entitled to gratuity and family pension till they are major, and the second wife Yogmaya Devi is not entitled to get pension and gratuity. Now we'll see what the division bench of the High Court said. An appeal was filed by the Yogmaya Devi before the division bench against the said judgment of single bench, which was dismissed by the division bench. Now the Supreme Court. Being aggrieved by the judgment of the division bench, Yogmaya Devi, with a special leave from the High Court, filed an appeal before the Supreme Court. So, the appellant Rameshwari Devi stated in her statement that Narayan Lal was not married to Yogmaya Devi. There is no documentary evidence on which the marriage between the two is proved. Honorable Supreme Court expressed the view that when they are living as a husband and a wife for long period, then a presumption of marriage is made out. In Hindu law, polygamy is prohibited. At the time of marriage, first wife must not be alive. If the husband gets married second time, whereas his first wife is still alive, the second marriage will be void and it will be punishable under section 494 and 495 of the Indian Penal Code. Hindu Marriage Act was amended in 1976, and by this amendment, according to section 16, first, that every child born out of the void marriage will be a legitimate child. The marriage of Yogmaya Devi was invalid. Therefore, she is not entitled to get anything from the property of the deceased Narayan Lal, but the child born out of that is legitimate child according to section 16(1) of Hindu Marriage Act. Therefore, they are entitled to receive property of their deceased father. According to Hindu Succession Act, if a person dies intestate, his property will be issued to his wife and his children. Rameshwari Devi was his valid widow wife, and her children and the children from Yogmaya will get the property. The Supreme Court held that the judgment given by the single bench of High Court was right and it had no right to cancel it. The court presumed marriage between Narayan Lal and Yogmaya Devi under section 112 of the Indian Evidence Act because they had been living as a husband and wife for a long time. Therefore, child born from their wedlock is a legitimate child as per section 16(1) of the Hindu Marriage Act. Now let's see what's the judgment. So the appeal was dismissed. Law points. Number 1. A child born out of invalid marriage is a legitimate child under section 16(1) of the Hindu Marriage Act. Second, the second wife of the deceased cannot get the status of a widow wife at a time when his first wife is still alive. The child born out of the second wife, being a legitimate child, is entitled to get right in the property of his deceased father. Fourth, the second wife is not entitled to get anything in the property of her deceased husband. So guys, meet you in the next leading cases. If you want us more leading cases, then let us know. And if you like the video, do like, share and subscribe our channel. Thanks for watching.